feel free, each of you, to address the questions as they come. One of them just coming in now, and again, I want to turn this over to either one of our speakers to answer this, but in bottom up, why can an SEP holder only charge the incremental value if the alternative technologies were also patented and were not free alternatives? Question coming from one of our attendees.
Yeah, that's a very good. This is Mario. I'll take that the first shot at it. I think it's a very good question. The question still comes down to what would have happened had there been competition to get their technology incorporated into the standard. And so we have to think about that type of competition. So if there was another alternative, what would have happened? That we can construct we can kind of reconstruct that competition that would have happened, and as I touched upon earlier, that we would expect the competition between those two technologies to push it at least down towards the incremental value above that. So you could have a price competition that where each player tries to undercut until finally we arrive at the incremental value. So I think that it is an issue. It was an issue that was raised in TCL versus Ericsson. I still think that directionally it has to be correct that when we have many other alternatives or another alternative, that's going to result in needs to result in a lower royalty rate than a patented technology that has very few alternatives and really is providing a substantive improvement over anything else that's available.
Yeah, this is Matt. I agree with Mario and all of that, and a couple of points I'd make. One is that, yeah, if it gets into a Bertrand pricing situation, in principle, if you've got a non-infringing alternative, but does have that would have a price as an alternative because it would apply and not infringing with respect to the patent, but with the product, then there'd be this, in principle, there'd be this arbitrage and bidding situation between the relative values and the determination of just incremental value. I'd make 2 points there. One is if there's a perfectly good alternative and they're both patented, the Bertrand equilibrium is zero value, which presents some fundamental difficulties in terms of equity and the patent system, which David Teese and others have pointed out in the economics literature. I mean, there are ways to think about that economically. That's not ultimately the final solution. But if there is an incremental value, that in principle is the issue. Secondly, doing the bottom-up approach is already so difficult in terms of the factual evidence that can be put forward from experts and alternatives and issues with respect to standards adoption, that looking at patents outside the scope of the actual dispute and making assessments of alternative relative value becomes even more difficult just from a detailed evidentiary basis. So the bottom-up approach does, even though it's conceptually correct, it presents real challenges in terms of generating the right level of evidence.
Excellent. Thank you so much. Another question coming in. Matthew, I want to start with you, and then we'll move on to Mario there. But is component licensing a contractual obligation? And is the refusal to license a component supplier an antitrust problem? Question coming in there. We'll start with Matthew on that, and Mario, if you'd like to contribute also.
Okay. Well, yes, this is certainly a very controversial subject. I would make a couple of points. One is, and I'm not a lawyer, so I don't mean to speak out of turn, but the details of the IPR policies of various standards organizations matter very much, and there needs to be a determination from legal expertise or an expertise with respect to the IPR policies as to what they might mean in terms of obligations, whether there's literally a contractual obligation to license all comers, whether the component manufacturers or not, would be a contract interpretation question, whether it's under French contract law for Etsy or or some interpretation of the IEEE situation in the U.S., although the IEEE did propound an IPR which advocated at least an indication of value at the SSU level, which you might think of as a kind of equivalent to component licensing. So with that said, whether it is or not is a legal question, I think depends on the legal situations and the particular standards in question. Whether or not it's an antitrust violation is also a very interesting point of controversy right now. Macon Delrahim is clearly of the view, of course, and the DOJ has been very active, especially with amicus briefs in various FRAND disputes on this issue, that basically my understanding is Delrahim's position is there's no possible antitrust violation for a patent holder to assert its patent rights. And if there is any issue with FRAND, it would have to be a contractual matter. That's not consistent with what a former Assistant Attorney General Shapiro had put forward, or prior joint policy of the DOJ, FTC had put forward when they did their investigations of FRAND policies in the earlier years, policy that Mario referred to. So where economists are going to come down on this, where the courts are going to come down on this, I think remains to be determined, including the appeal of the dispute with the FTC and Qualcomm that's pending review in California right now.
Excellent. Mario, any thoughts on that before we move to another question coming in?
Yeah, actually, let me just add one thought, and that is that the issue here is this kind of this idea that using it at the component level somehow undercompensates or doesn't fully account for the downstream value, and so that patent holders should be able to get that, be able to have some royalty on the downstream product. And so that isn't necessarily economically correct. And the way to see that is to think about a patent holder or a component manufacturer, that has significant market power in the upstream market. And so that's not hard to imagine when we think about Qualcomm. So when they're pricing their chips, if you have market power, or if you're a hypothetical monopolist, you're going to anticipate what the downstream demand is. And so when we're looking at that component, it's already going to incorporate and account for the value that upstream component can charge, kind of the maximum amount that it can charge off of its residual demand. And so it just as an economic matter doesn't necessarily undercompensate patent holders to start at that place.
Excellent. I think we have about 4 minutes or so remaining, and I want to get these questions in that our attendees are asking now. I know they may be long questions. Let's see if we can get to them, because I think that this will be very, very beneficial for them. One on holdout. Doesn't holdout become a more significant problem as a patent holder's portfolio ages, and given the short limitation period in jurisdictions such as China? Thoughts on that from either of you?
I would agree with Mario. It's contrary to some of the writings out there. I disagree that there's a symmetry between hold up and hold out. Hold up is clearly a potential economic problem, which is straightforward. Hold out seems to be a reference to the practicalities and the transaction costs of litigation. But putting those aside, as economists are wont to do, a patent holder has an absolute right to assert their patent rights and to obtain through the courts full compensation for those rights. It may be very expensive to do so, and it may be time consuming, but in principle, that's always their right. And even if the portfolio is aging, they have the right to go back and claim full value for the portfolio back through time during the whole period of time in which it's infringed. So I understand that the very large transaction costs of litigation and the uncertainty of litigation presents practical difficulties and frustrations for the portfolio holders. But I think I agree with Mario that it's not, in principle, a symmetric situation with holdup.
And another question, somewhat pertaining, but why not create? Attendee wanting to know, why not create a patent tribunal similar to the copyright royalty tribunal, because these are essentially compulsory licenses.
Well, it's probably your turn, Mario, but I think that's a very interesting idea, and there are a lot of similarities, and there are some writings along those lines. It's an idea that might be useful to explore.
Yeah, I think so. And I think on the issue of holdout, and particularly in China, I think you have to really look to, I mean, we are seeing an increasing amount. We do a lot of work now in China in normal patent infringement cases and standard essential patent cases. And so China is really thinking about these issues. And so if you have strong patents and your portfolio is strong enough and valuable enough, I think you do have the opportunity to assert your portfolio in China, even if there are some difficulties there. And so I think that's something to think of. In terms of the tribunal, I think that could be. I think there's a lot of details that would have to be worked out. In particular, making sure that the royalties are align with the value on a worldwide basis. As I showed, the portfolio strengths can be significantly smaller for licensees outside of the U.S. and Europe.